So any information that is provided here should not be construed as legal advice. If you do have questions regarding your specific matter, please feel free to call our office or a lawyer in your area to book a consultation to receive tailored advice specifically for your information and for your circumstances. So, quick intro for all of the panelists you see before you. We have Joseph. He is an articling student at the firm, and he's set to be called to the bar in Ontario in June of 2024, which is rapidly approaching. Joe is a graduate of the Ted Rogers School of Management at Toronto Metropolitan University, or formerly Ryerson, and Queen's University Faculty of Law. So as Joseph enters the next phase of his legal career, he's committed to positively influencing the lives of those facing difficult family situations. We also have Shanza. She's our other articling student at the firm. Again, she's also being called to the bar in Ontario in June of 2024. She's a recent law graduate from Osgoode Hall, and she's focused on launching her legal career in family law and is dedicated to providing empathetic and proficient legal support for those navigating family-related complexities. Then we have Russell. Russell is the senior partner and founder of Russell Alexander Collaborative Family Lawyers. If that was
you make it sound like it came in with a walker or something. Come on.
Here's
the cat parking out front, right? Or whatever.
There's Russell.
Sorry.
With his 25 years of experience. Oh Russ is a great source of knowledge and expertise, and he uses that to serve his clients in all aspects of family law, and he helps families cope with the difficulties of separation and divorce. And then we have me. So my name is Stephanie, for those who don't know me. I've been at the firm since 2018, and I was called to the bar in Ontario in 2022. So I'm now an associate lawyer at the firm. I completed my undergraduate degree at Queen's University, and I obtained my law degree at University of Liverpool in 2020, graduating with first-class honors. All of us that you see before you on your screen, we're all trained in collaborative practice. And I'm committed to assisting clients through what's a traditionally difficult time by approaching matters with empathy, integrity, and compassion. So with all of that said, let's jump right in. So we have some great topics today that we want to touch on, all geared around parenting. You'll probably hear us, talk about the custody and access terminology that's now been changed. So I'm just going to jump right in. Joseph, what is decision-making responsibility, types of decision-making responsibility, and, maybe touch on what joint versus sole, split, all of as much as you can in such a short amount of time.
Before we get to Joseph, Steph, do you find it hard letting go of that language of custody and access? That's what you kind of grew up with in law school and your training, and now it's...
Yeah, it's like right when I'm called, they're like, just kidding. We're no longer using those terms. But,
we're going to talk about that more, but let's get to Joseph. I just think it's kind of hard to let that go, right? Because a lot of our clients, that's all they know from media and the movies and everything else. So,
no, for sure. And so just what Russ and Steph are speaking about actually is that custody. So that was a term that was used prior to March 2021, and that has now been switched on for everyone, and through legislation to decision-making responsibility. So what exactly is formally custody, now known as decision-making responsibility? It refers to the right to make significant decisions about a child's life and well-being. And those decisions can cover various areas, but predominantly they constitute decisions surrounding health, education, religion, and other important matters such as Section 7 expenses, which we'll speak to later. And decision-making responsibility, it is determined by a separation agreement or a court order. And there are various types of decision-making responsibility. So the first is sole decision-making responsibility, and that is when one parent has the sole authority to make important decisions regarding the child's care, education, religious institutions, and wherever they choose to practice those instructions, as well as their welfare. And with that, there is no requirement to involve the other parent in decision making unless their consent is specified otherwise in an agreement or court order. The second type of decision-making responsibility is joint. So with joint decision-making responsibility, both parents share the right to make important decisions about the child's care together. And with that, it requires cooperation and communication between the parents for effective decision-making. Another term of decision-making responsibility is what's known as split decision, or that's always a tough one, bifurcated responsibility. And that involves dividing specific areas of decision-making authority between parents. So what that means is that each parent would have sole decision-making authority over certain aspects of the child's upbringing, whether some other decisions may require joint agreement. So, for example, in a split decision making arrangement, one parent may have sole authority over educational decisions, while the other parent has sole authority over medical decisions. So, this division of responsibilities, it sort of allows each parent to exercise autonomy in their respective areas while still allowing them to collaborate on major decisions affecting the child in other areas. So it's another option that people sometimes go for. And then finally, there's what's called de facto decision-making responsibility. And that occurs when children live with one parent without a legal decision-making responsibility arrangement put in place. And this arises when spouses live separately and the children reside with one parent full-time, and that's arrangement sort of been accepted by the other spouse. So what's really important to note about that is that legal decision-making responsibility is established through a separation agreement or court order, and that's de facto decision-making, it doesn't have that.
Go ahead.
Do I have your permission to tell a story?
100%. We love stories.
Our audience loves the stories, right? They want to hear what's going on in the trenches. What are we doing? So I would always get clients coming in pre-pandemic, right? When people used to come to the office regularly. And they want to know, well, what's the difference between sole custody and joint custody and, this and that. And I always tell them, you can go ask 10 different lawyers and you'll get 10 different answers, right? Because even lawyers can't even agree on what the definition is. But what I would say is most of the decisions that would come into play when this distinction was in place, it's a little bit different now, really have already been decided. So religious upbringing, usually by the time I see the couple, the child's born, they've decided on the religion. Educational upbringing, they've decided, Catholic school, Jewish school, public school, private school, Montessori. Those wheels have already kind of been set in motion. Health decisions, another big one. Jehovah's Witnesses will be concerned about that. But if you're not a Jehovah, most families defer to their family doctor, right? That's what the doctor recommends. You may need to see the specialist. This is what the specialist, 99% of the population is going to refer to whatever the medical professionals are recommending, including counseling, depending on your child. The other big one's mobility. Where's this, and we're going to talk about this in a little bit, but where's the child going to reside? Again, separating couples, they're usually going to reside in the same neighborhood. Very rarely, maybe one in a 20 or 30 is going to move out of province for employment or whatever. So all these big decisions that people get excited about regarding the language that we use, most of them have been decided, or we're going to defer to somebody else. So, and I think it's good that the government watered down the language and got away from these words of sole custody, joint custody. That sort of creates this image, there's a winner and a loser, right? I won, you're an access parent, I've got custody or whatever. So it takes a lot of the fight out of the parenting issues that we're seeing. But back to you, Steph. Just want to share that story. Hopefully our audience got something out of it.
Yeah, no, that's 100% right. And just sort of to tack that on is, we'll touch on it actually in a minute. Joseph, I'm going to ask you about best interest of the child. But when you think about, kids growing up, separation is hard for anyone to navigate, especially kids, right? Children. So no child wants to grow up thinking, one parent thinks the other is a loser or an unfit. Right. It's not beneficial for anybody, especially the kids. And it's really, you want to focus on how they're going to grow and overcome and, succeed and thrive throughout life and even despite a separation or divorce. So, Joe, I'm actually going to flip it back to you. What is this, best interest of the child? We hear that a lot. What's it mean? How does it help guide parenting decisions?
Yeah, so the principle of the best interest of the child, it really is a fundamental concept that we've sort of incorporated in family law. And it's a principle that prioritizes the well-being and welfare of the child above all else in legal proceedings and parenting decisions. And it's a principle that recognizes that children have certain rights and interests that deserve protection, regardless of any disputes or conflicts between parents. And this principle serves as a guiding framework for making decisions related to decision-making responsibility, parenting time, and other parenting arrangements such as relocations. And this principle truly emphasizes factors such as the child's physical, emotional, and psychological needs, their safety, their stability, and overall development. So when determining the best interest of the child, there's various factors that are taken into account. And these factors are also outlined in Section 16.3 of the Divorce Act. Some of them include the child's age and maturity level, the child's relationship with parents, their siblings, or any other significant individuals in their life, the child's health, including any special needs or medical concerns they may have, the ability of each parent to provide a stable and nurturing environment, the child's preferences, and if they are of sufficient age and maturity to express them and how they choose to express them, any history of abuse or family violence within the family, and the importance of maintaining continuity in the child's life, whether that be through school, their community, or extracurricular activities. And the courts use the best interests of the child as the primary criteria when making any decisions about decision-making responsibility, parenting time, or any other parenting arrangements. And this ensures that the child's welfare remains paramount and that their rights are protected even in the midst of any parental disputes. So this principle of the best interest of the child is enshrined in various Canadian laws and legislation. As I mentioned, it's in the Federal Divorce Act, as well as the Children's Law Reform Act if the parents aren't married and they're governed by provincial legislation.
Russ, was I about to step on?
Joseph took the words out of my mouth. I was just going to say Children's Law Reform Act if you're not married, but he read my mind, so I'm just going to zip it. But the legislation almost mirrors itself, right? Same factors, same discretion.
It's pretty much the same wording.
Yeah. Fact-based analysis, lots of leeway to judges hearing custody matters to give different factors different weight depending on what he or she thinks is in the best interest of the child.
Yeah, and judges pretty much go to that. Like that's their first point of direction is the best interest of the child test with anything they have have in front of them.
Exactly. And that can, take on so many different schedules and plans. So actually, Shanza, I'm going to flip it over to you. What are some parenting plan essentials? What are components that can, separating spouses can use to make a, effective and comprehensive plan?
Yeah, for sure. Thanks, Steph. So when we talk about an effective plan, we talk about a plan that is sufficiently detailed in addressing all the parenting arrangements the parent will have moving forward, like post-separation. You will start with the more basic components, which will include living arrangements and schedules. This part will outline where the children will live and the schedule for when they will spend time with each parent, like how weekends will be spent, how weekdays will be spent. It has to be comprehensive. So include pickup times, drop-off times, how holidays, special occasions, we go into all that details. And then an effective schedule will address what I said above in a way that will be realistic. It will consider each parent, if they're working, work schedule, the children's school, extracurriculars, travel times, what's feasible, what's not. It differs from like family to family, what's going to work. In your schedule, you will include decision making, whatever you've come up with, whatever you end up picking from what Joe just mentioned earlier. There's solo, there's joint, there's split. Who's making the decision? All of that gets worded into the plan. It's also a good idea to address extra costs in the parenting plan. I know there's child support for basic expenses, but with kids, there can be extra needs. So maybe something like school supplies, any entertainment, sports, art, all of that could also be addressed in the parenting plan. It's great to have, we should have communication guidelines in there as well. Include how often parents will communicate, how they will communicate through phone calls, email, apps, what tone of communication is expected, respectful, should there be any boundaries? You want to throw all of that in there. And just having these communication guidelines, it relates more to not just the nitty-gritty of drafting the plan, but the more broader aspect of parenting and ensuring that you're providing the kids with stability and you're thinking in terms of their well-being and what's their best interests are. Moving
Yeah.
along.
Sorry, go ahead. Go ahead.
Jeffress? Okay. And then there's other things you want to include in your plan. I know Russ hit on health, checkups, emergencies. You want to have a plan for everything. We're also looking at addressing education, extracurriculars, what activities, how the costs are shared, who's responsible for taking the kids, driving the kids. Most of the plans also include a dispute resolution clause. So this deals with how, there's going to be disagreements. So this deals with how disagreements will be resolved. It's good to include mediation in there or some other form of conflict resolution before you want to consider going to court. And lastly, I'll just add that in addition to being comprehensive, like everything I mentioned above, and realistic, you also want to make sure that the schedules are flexible. So life changes happen, circumstances change. There could be a change in job, relocation. So it's good to have the plan account for any of these changes that could occur in the future and include a process for making changes to the plan where or if any such events do occur. And the overarching goal of the plan is, like, when you're drafting it, just keep in mind it's for the children and what's best for them. So when you're drafting the plan, make sure you put the children first.
100%.
Professionals are here to help draft a fair plan. It's a good idea to seek help. Like if you don't know, just seek help from lawyers, family professionals. There's a lot of resources out there to make sure you have an effective plan.
Thanks, Shanza. And it's actually interesting you mentioned sort of these rules or these guidelines for separated parents, because the courts, we're seeing more and more. I just had a file and the judge brought that up, pointed to the rules for separated parents and how their communication should be. You're not going to put the other parent down in front of the kid. You're not going to, try to transfer messages back and forth through the children. So it's really, really important to put the best interest of the children first, 100%.
Let's try to include those rules in our show notes. I know when you meet with your lawyer for the first time, you want to start thinking about your parenting plan. I get clients who come in, I want the children 50% of the time. Okay, well, how's that going to look? Who's going to care for the kids while you're at work? Right. And we start drawing these blanks, right? So I start fleshing out the details. Are your parents involved with caregiving? Are they in the community? Do you have family and friends in the community who can help you pick up the kids from school? So, the plan's got to have some common sense to it as well, right? What do you do when new partners are introduced to the children? Do you give notice? How's that communication what's that communication going to look like? And I've seen parenting plans fall apart at the seams when the judge asks to see the parent's work schedule, and they're not available for 3/4 of the time that they want the parenting to occur. And they unless they have a backup plan, like, yes, I have daycare, I have a babysitter, I have my mother coming in to assist. If they draw a blank, then that's not an effective parenting plan. So we, like all four of us, we'll work with social workers at the beginning in the collaborative process. Usually the first thing worked out in a separation is the parenting plan, or at least a draft one that we can get through the next 4 to 6 weeks. But those are some great tips, Shanza. Thank you so much.
And another great resource too is the AFCC, which is the Association of Family and Conciliation Courts. They have a lot of great resources, especially with respects to drafting parenting plans as well. So that's also, I think we can include that in the show notes as well, like the Ontario chapter.
Yeah, 100%.
It could be week of pay, it could be alternate weekends, it could be 3-2-2. Flexibility, the options are really endless. Extended time in the summer. It all depends on where the parents are residing, what the plans are.
Exactly. And, understanding this regular, whether it's a shared parenting arrangement or a split, or, are there virtual arrangements as well, especially with, COVID, this aspect of virtual parenting time has really skyrocketed. So Joseph, I'm going to flip it back.
Steph, let's just look at some of these audience questions.
Sure.
Thank you everybody for sending them. What age does the child, does it becomes the child's decision? Well, every child's different, right? We have 12-year-olds who are mature, old souls that are like 18. We have 16-year-olds who act like 9-year-olds. There's no trigger, but I would say the older the child gets, the more weight and consideration the court would consider their wishes. But I thought that was a good question to tie into this section of the program. But back to you, Steph. Sorry for interrupting.
And actually back to you, Joseph.
Yeah, no, thank you. So going back to parenting time, so that was also one of the big changes that they made. So prior to March 2021, parenting time was known as access, and now parenting time is used in most cases. There are some cases where access is still used, more so with Children's Aid Society cases, but pretty much with majority of family law cases, parenting time is the term that's used. And it refers to a time a child spends in a parent's care, regardless of physical presence. So what that means is the child may be in sports, maybe at school, they may be at the doctor's. So it doesn't matter that the child's not necessarily in the physical presence of the parent, but that the child is in the parent's care. And what's really important to note is that parents, regardless if you are the primary parent in terms of the child is primarily residing with you or the child secondarily residing with you, is that all parents have the right to parenting time. However, the only caveat with that is that a court may deem that it may not be in the child's best interests to have that parenting time exercised. So with respects to parenting time arrangements, they can be detailed in a parenting plan, as Shanza discussed earlier. They can be outlined in a separation agreement or through court order. And it may include specific schedules. So as Russ mentioned, every other weekend, or there can be a flexible arrangement. There's endless options. And what's really important too about this parenting time arrangements is that it does not grant decision-making authority to the parent without decision-making responsibility. So just because the child's in your care at that time doesn't mean that decision-making responsibility is flipped to that parent. The only caveat with that again is that there may be day-to-day parenting decision-making. So that's on a lesser scale. So it doesn't necessarily reflect the health or education decisions, but more so the day-to-day decisions, such as maybe what's for dinner or what the child can watch for TV that day, the less minor decisions. And with that, there are different types of parenting time arrangements. The first one I'm going to talk about is a shared parenting time schedule. And funny enough, it doesn't mean 50-50. A shared parenting time schedule is when at least the child lives 40% of the time with each parent. So 40% is a threshold in that sense, and that number is actually regulated by the child support guidelines. There's also split parenting time, which occurs when parents have multiple children, and each parent will primarily care for different children. So if you have two boys, one boy may live with you and the other boy may live with your spouse. And that's what's considered regular parenting time. Then we go into what's called supervised parenting time. So supervised parenting time is arranged if there are safety concerns and they exist during visits or exchanges, and it requires a neutral third party to be present during visits or exchanges. And supervision can be agreed upon by parents, or it could be mandated by the court. So one of the key resources that we use for exercising supervised parenting time is the use of supervised access centers. So supervised access centers provide supervised visits and exchanges in a safe and neutral environment, and they're all staffed by trained professionals or volunteers. and they're offered by ministry-funded organizations or through children's aid societies. So what happens is during supervised parenting time is one parent who is either mandated by the court to do so or it's agreed to by the parents is that they will be in a setting where both the parent and the child have parenting time, but it's closely monitored by a volunteer or supervisor. And Steph did mention virtual visitations. So what's really become prominent since COVID is the use of virtual visitations. So that can include scheduled FaceTime calls or any other video calls, Skype. So that's just a way for parents to exercise their parenting time while not necessarily being in the same room with them, physically at least.
Yeah, thanks, Joseph. And, you know, there's a lot of different, you mentioned supervised, I think they still call them supervised access centers, even though the terminology has changed to parenting time. But there's multiple. There are some that you require a court order for, but there are other, let me think, there's Renew, there's Braden. Those are supervised access centers that you can, you know, agree to a schedule. And so
I was just saying, it doesn't even have to be a supervised access center. If both parties agree that someone's one of the spouse's parents can be present while there's a visitation going on, that can count as a neutral third party if the parents agree to. So it doesn't necessarily have to be at a supervised access center. If the parties can agree to any neutral third party who they feel comfortable, then that's more than acceptable.
100%. And, you know, we actually see that more and more, especially because it provides a cost-saving alternative than a supervised access center. So Joseph brought up, you know, the fact that supervision or supervised parenting time could be court mandated. So the role of the court and how, you know, these parenting decisions are made is really, like we've sort of mentioned throughout, what's in the best interest of the child. So judges will consider the variety of factors that Joseph previously mentioned. And if there's still a dispute, if there's still, you know, because we're looking at a one spouse said versus one spouse said, they can also get what's called the Office of the Children's Lawyer involved. And what that would entail is the judge would make an order and request the OCL, as we just shorten it, to get involved. And they would conduct an interview and they would conduct their own sort of investigation. They may meet with both parents. They may speak with the kids, depending on how old they are. They may speak with teachers or, you know, other adults in the child's life. And they would provide their thoughts, their recommendations, and a report on what they view is in the best interest of the child. So those are often used when there is a dispute or there may be parenting concerns, but, you know, we want a neutral third party to take a look, see what's going on, and provide that information to the court so then the judge can help, you know, with their guidance, their recommendations. And maybe sometimes it brings the two parents closer together because they have a better understanding of what's going on in the other household when they're not there. I find a lot of times disputes or arguments stem from just not knowing, right? You're not present in the other parent's home when they're taking care of the child or the children. So our mind can just wander. So having that type of report from the OCL can be extremely helpful in reaching a settlement. If for whatever reason, the Office of the Children's Lawyer is unable to take on your matter or take on your file, there are private reports that you can pursue. And, you know, if both parties are consenting, and that's called a Section 30 assessment. So it's called a Section 30 assessment because in the Children's Law Reform Act, it's Section 30. So that's an alternative. They usually do have a cost associated because you are seeking a private professional to conduct this assessment. But it can be a great tool, both, you know, in court and outside of court to sort of help facilitate discussion and promote settlement and an understanding of what is in the best interest of your child or children.
Steph, I know you said OCL, and I know you said Office of the Children's Lawyer. Can you just explain to our audience what that is and what that office does, just briefly?
Of course. Yeah, I know it's hard because we use these terms so
Yeah, it's
frequently
like
in the day to
second nature
day.
for us, right? Yeah.
Exactly. So the Office of the Children's Lawyers, traditionally a somebody with a social work background, and they are there to provide a voice for the child or a voice of the child report. They're always going to keep the children at the forefront of the process, and focus on what are their needs, what's going to impact their well-being, what
Mhm.
maybe it's something right now, a certain schedule or a certain dynamic right now, but because they're so young, maybe it needs to evolve, and there's gradual changes as the child grows up. So they're really there to be the child's voice.
This is another tool in the judge's toolbox, right? It's provided for by the government of Ontario. There's no cost. The judge makes a reference or an order for it. The children's lawyer can decline to get involved, is depending on the resources. They usually do, but sometimes they just don't have the resources to meet every case. But it's just another option that's available to the court.
100%. And what happens, Russ, if for some reason there's, either an agreement or an order in place for parenting and the other parent violates it or just refuses?
Yeah. This is such an interesting topic, Steph. First thing, as a lawyer, I want to think, okay, what am I dealing with? Right? You have the status quo. So this is just what parents did on their own. That's kind of evolved over time. And most judges don't want to disturb the status quo unless it's not in the child's best interest. If it's working, they might defer to keep the status quo going, right? You may have a verbal agreement or a separation agreement. And then you need to say, okay, well, what remedies are available within the agreement to deal with non-compliance? There could be a dispute resolution provision that you may need to follow. There could be sometimes agreements will defer decisions to third parties, such as parenting coordinators, if there's a specific dispute over a pickup or drop off time or a holiday schedule. So you want to examine the agreement first, see, okay, what options are available pursuant to the agreement. And then you may have a court order. Again, what does the court order say? Believe it or not, there's some court orders that say, for example, holiday or Christmas access would be shared 50-50. And that's all it says. So what does that mean? It doesn't say anything, right? You can't enforce that order because it's not specific enough. Or Christmas Day is going to rotate, but it doesn't say who gets what day, right? And so you want to look at the court order and specifically what's in the court order may provide some type of dispute resolution mechanism. Oftentimes, if it's an active case, the case management judge may just say resolve any disputes by 14B to the case management judge, which is a type of motion that you do in writing, procedural, mainly unless the judge orders otherwise. So if that mechanism is in the order, then you need to follow that process. All right, so let's just say, hypothetically, you have a court order. Great, now I can enforce something. What does it say? Yeah, it's specific. That parent didn't comply with this order. What am I going to do next? Well, common sense would dictate that you call or write the other parent. There could be a simple explanation. Car broke down, worked overtime, family was sick. Who knows what the explanation is? Let's see what the response is. No response, then write to them. No response. Consider whether a case management judge is available to assist. If necessary, you may want to bring a motion. I would start with a motion for direction for enforcement. So what you're saying is we have this order, ask for the court's guidance in terms of how to enforce the order. Lots of lawyers come out guns a-blazing with a contempt motion. Contempt is a criminal standard of beyond a reasonable doubt, and the order needs to be very specific, and the breach needs to be very clear. Very rarely do you check off all those boxes. If you do, the responding parent has a right to have a hearing and call evidence, and then the judge needs to make a decision. So you're looking at months before you get any real effect to a contempt order. And then if there's a contempt finding, the judge has a range of options he or she can impose to force compliance. The highest threshold is obviously incarceration. That's a tool of last resort for a court to go to contempt and to deny somebody's liberty. It's questionable as to whether or not it's in the child's best interest as well to have this kind of outcome over a parenting dispute. So what do you do? You look at all those things I talked about. What am I dealing with? Is it status quo, verbal agreement, written agreement, court order? What mechanisms are within the order to allow me to address those issues? How specific is the agreement or order that the court's going to find that this person violated? But before you get all that, find out what the other parent's explanation is. It could be something very simple. So those are some common sense approaches to take. Very expensive if you involve the court. You could save that money, take your kids to Disneyland, put it in an RESP, use it for their college or university. Don't spend it on the lawyers unless you have to. If you're going to have to do a little bit of compromise, move some dates around, maybe a makeup visit or two, that's certainly going to be in the family's best interest in terms of saving resources and also in the child's best interest. Back to you, Steph. Thanks.
Thanks, Russ. And that was, a great overview. And it really goes back to the good old, it depends, right? There are so many things that you have to think of and you have to consider, and, you have to sort of do that cost benefit analysis yourself as well.
Maybe instead of after hours, we'll just call it depends.
Right? You know what? That has a ring to it, and it has a lot of truth to it.
That's true.
Thanks, Russ. One of the topics that we're just going to switch gears a little bit, we see it, we hear a lot of, and, it is of concern is, when does it get to the point that there's any parental alienation? And, what do you do if that becomes an issue? Shanza, I'm going to hand that over to you.
Thank you, Steph. Yeah, no, you're right. Parental alienation is a very serious issue that affects many families that are going through a separation or divorce. And I think I should start with what is parental alienation. Parental alienation it's where one parent manipulates and undermines the child's relationship with the other parent. Imagine this. You've got a child and who's stuck in the middle of a war zone between mom and dad. Like on one side, there's the parent who's playing dirty. They're kind of bad mouthing the other parent or making it really hard for them to see the child. And on the flip side, there's the other parent who's just trying to be there for the child, and just trying to exercise parenting time with them, but they keep hitting roadblocks because of the other parent. In reality and in practice, parental alienation could mean the kid not getting enough time with one parent, the alienating parent playing gatekeeper with phone calls or visits, or even making up lies about the other parent. Their end goal seems to be to turn the child against the other parent, which causes all sorts of emotional distress and damages the relationship. The consequences of it can be really devastating. There's kids, the kids feeling like they're walking on eggshells, they're dealing with anxiety, they're struggling to trust the parent, like which parent to trust, which parent to believe. It's heartbreaking stuff. The children's world, it becomes consumed by the conflict between the parents. But it doesn't have to be that way. Recognizing the signs of alienation is the first step. If there are any of these signs that I mentioned above, get the pros involved: therapists, counselors, lawyers. They can all come in and they can help families kind of untangle the mess. The law also addresses alienation. One of the factors for determining, and I know Joseph went into, we all kind of talked about it today, the best interest of children. One of the factors the court looks at is each spouse's willingness to support their relationship with the other parent. Also, when alienating a child, if the parent is ignoring a court order, then there's recourse in that sense. There was a case from 2020. I was reading about it, and this mother, she kept the child from the father, and she was punished by having her spouse's support reduced to $1 a month. So the court really considers this behavior evil, and there is recourse within the legal system for such behavior. If you are like, for our audience, if you're here and you're concerned that your spouse is interfering your relationship with your child, I would say first and foremost, contact a lawyer. We can initiate court proceedings. The courts, they address alienation. And like while you're trying to manage these things, try to maintain as much contact as you can with your child and keep the contact positive. Like don't engage in a counterattack that will only make things worse and it may further destroy your relationship with your child. And finally, maybe try contacting a counseling professional so you can get started on a repair process with your child.
Yeah, and I think that's amazing advice too, right? Or tips and tricks to overcome when there may be concerns of parental alienation. Russ?
Yeah, I've seen trial judges where both parents wanted the child in their care full time. Both had great parenting plans. Both were professionals and great parents. The case turned on whether or not the judge thought one parent would encourage the child's relationship with the other parent more. And that was the tipping point. So when we, these cases where these parents are doing everything they can do to undermine the child's relationship with the other parents, usually that ends up very badly for that parent, because at the end of the day, the judge wants, and studies show, that children who have good relationships with both parents turn out to be healthier, more productive members of society. The children who do not end up in the criminal justice system or the young offender system, dropping out of school, drug addictions, crime, all the rest of it. So it's really in the child's best interest to have a good relationship with both parents.
Thanks, Russ. And I'm just taking a look here at some of our Q&A that's come in. So we do have a question on relocation, and Shanza, I'm going to flip this back over to you. What are the rules in the legislation in, Ontario about moving with child or children post divorce and separation?
Yeah, no, for sure. I'll take over stuff. So there has been changes in the law regarding relocation since March 2021. So it wasn't just the terms that changed, there's been more changes to the law. So according to the law, there is a difference between change in residence and relocation. Relocation is the important one, or the scary one, because relocation is when the change in residence will have a significant impact on the child's relationship with the other parent. And what that means is you're moving so far away that it's become harder for the other parent to continue to exercise their parenting time. An example would be a parent's move with their child from one province to another, and that would generally be considered a relocation. Not all moves are relocation, but sometimes, like I know I said moving provinces, but sometimes even a move of a short distance can be a relocation. The bottom line is there a significant impact on the parenting schedule? And if there is, then you are relocating. Now, if you're moving and your move is not a relocation, then all you need to do is give notice to the other party so they can continue to exercise their parenting responsibilities. You want to let them know when you're moving, your new address, and that's pretty much the end of it. But if you are relocating, then there are additional requirements, and you do need the consent of the other parent to move. If they don't consent and they can object to your move, the courts get involved and they get to decide if the relocation should be allowed and if the relocation is good for the child. In terms of the extra requirements, if you are relocating, you have to give a notice, so a 60-day notice, letting the other parent know of your intention to move, your new address, and you also have to propose a new parenting schedule that the current plan could be changed to that would still allow the other parent to spend time with the child. Like I said earlier, the other parent can object to the move, and if they do, and if they file something called an objection to the relocation, or maybe even if they start a court application opposing the relocation, in that case, you cannot move with the child until the court makes an order to allow your move. Now, if you're the parent who is objecting to the move, you'll have to explain why you object. And you also have to give your views on the new plan that the parent proposed as to why that doesn't work. When it gets to court, the court will look at the best interests of the child. So all the factors from earlier today. And I think some of the additional things the court will look at will include the reason for the relocation. What is it for? Is it for a new job? Is it to be with a new partner? The reasons matter. And then the court will look at the impact of the move on the child's family connection to the new community versus the current community that they were living in. They will also look at how involved each parent is. So do one or the other parent have more involvement with the child, and that's a factor that'll come into play as well. The court will also look at if there's a court order that says a child is supposed to live in a certain place, and that will definitely play some weight. They will also see if the proposal that you planned is reasonable or not. A court will want to know if the parent who is moving another one would be if the parent who's moving has denied parenting time in the past. Because for the court, this may predict future problems. The court might also want to know if the person who does not want the move has failed in the past to use their parenting time or not pay child support. Anything that will help the court decide, they will look at all those factors.
Shanza, that was a great, super comprehensive. There's so many factors and considerations, and it really all ties back to what's in the best interest of the child. We bring it up a lot today, but it really is so important to remember that the reason that you're either moving or proposing these changes or creating a parenting plan is to sort of create a guideline or a guide map. I don't know what the best reference would be, but it's to really to provide clarity of what the future is going to look like and putting your child or your children at the forefront of importance there. So anytime things come up, you might not expect things, like Shanza said, maybe there's a new job opportunity for one of the parents and that parent has primary residence, meaning that the child or the children are staying with them the majority of the time. Or say something comes up and there's concerns of parenting time. Maybe when the child or children are in one parent's care, there seems to be a lot of concerns or behavioral issues or things that weren't originally there at the start. So anytime you want to modify or change a parenting plan, sort of like what Russ said, you want to look at whether it's an agreement or an order, are there any sections or dispute resolution clauses where if you want to make a change or you want to provide a change or propose a change, you have to go through these certain steps. If there aren't, maybe it's something that you can discuss with the other parent and agree to between the two of you, focusing on how is this going to impact their child or children, what's going to set them up for the most success. So those are sort of the first steps that we traditionally like parties to do because it's more collaborative, it's, less contentious, and it's more cost effective as well. Mm-hmm. If it comes to a point where you can't agree, you're not on the same page, that's when you want to really look towards maybe, obtaining the help of a lawyer or a family professional, or in some, more severe cases, the courts. So there are all of these, resources and tools that we mentioned throughout today's, after hours program. So really utilize those, because if a change needs to occur, it's better to sort of deal with that as it comes, rather than letting it kind of prolong and enter into a new status quo or a new everyday life. So I'm going to flip it over to you one more time, Russ, about, support resources. Where can you find, there's legal support, but there's also emotional support. We touched on how this can be a really turbulent time for everybody, parents and children. So where can people turn to for those types of resources?
Yeah, great question, Steph. I think just back up a little bit on mobility. We did a whole series on the Divorce Act changes, just talking about mobility. Shanza did a really good summary here, but we talk about it in depth for 2-3 hours. There's onuses, special provisions if you're a victim of domestic violence. But in terms of mobility and Steph's comments, you want to put people on notice as soon as you can. The mobility provisions require it, but even for changes to the separation agreement, let's just say, for example, we're modifying a parenting order. The parenting has changed maybe from joint parenting to primarily with one parent. Put the other parent on notice, because there could be a retroactive support claim. And the court's going to say, well, when did you notify the other parent that you want this change? So you may want to seek a reduction retroactively or an increase. And if you can say, yeah, well, I sent an email 10 months ago and it took me this long to get it before the court, the court is likely going to act on that and act retroactively. So this idea of notice, it's common sense if you want to resolve it outside of using lawyers and going to court or mediation. But more importantly, or as importantly, if you want to preserve your rights in terms of doing a retroactive adjustment, if you have that written notice, whether it's an email, letter, something we could produce to the court to say yes, as opposed to he said, she said. Even sometimes text messages is enough to put another party on notice that a change has occurred. It's gonna help you at the end of the day if you can save that, pull it up later. So resources, great question, Steph. Emotional, sometimes we see clients when they're at their worst. There could be infidelity. They've lost trust in their partner, gambling, addiction, violence, domestic abuse. They may lose their home. They're going to lose their friend group, their identity as a married couple in the community, their income, their pension, their children, their liberty, right? Everything's in play. So we really get people at the bottom of the roller coaster. And we're not social workers. We're not medically trained. The ones that physically present themselves as being overwhelmed, I encourage them to talk to their family doctor, who's going to have the resources available. Or go into the hospital, right? If they're suicidal or they're just clearly not themselves, go to the emergency room if it's an extreme situation. The ones that aren't that extreme, we have a series of social workers we could deploy to help them with individual counseling, partner counseling, parental counseling in terms of developing their parenting skills. John Howard provides a PARS program for people who have committed domestic violence against their spouse. Lots of resources available privately. We can give you a list of social workers and counselors. You can also research them online. Lots of these services are available now in northern and rural communities. Thanks to the technology of Zoom and Skype, where counselors in Toronto can provide services 18 hours in Northern Ontario electronically. Lots of people are doing that with their family doctors and psychiatrists and other specialists that they need to see. It can be done electronically. So explore that. Certainly talking to friends and family members who have been through similar circumstances may have resources available to you as well. that some of these resources will tie into what I'm going to talk to in a moment, but the government of Ontario actually has some excellent resources. Canadian Mental Health has resources available to you. There's 1-800 helplines that you can contact day or night if you need immediate assistance. So there's lots of support here for you if you're having a tough time going through your separation or divorce. In terms of legal resources, well, you have today's program. I know my firm does a lot of podcasts, webinars. We write blogs and articles. We have over 1,000 articles on our main website, FamilyLLB.com, covering just about every aspect of divorce that you can imagine. We also produce YouTube videos. So if you process information through videos as opposed to reading, we have videos available for you as well. We're not the only firm in town that does this. There's lots of other great lawyers in Ontario that provide similar resources through their websites and platforms. So if it's a licensed lawyer in Ontario, it's likely you're going to be getting reliable information that you can act on. I would avoid internet information if it's not coming from a licensed professional. They may not know the laws in Ontario or the resources that are available. Lawyers are governed by the Law Society of Ontario, and Law Society collectively provides a lot of invaluable resources to not only lawyers, but to members of the public. For example, they have the lawyer referral service that you can contact. They'll provide you with a certificate and connect you with a local lawyer where you can get some free legal advice. I think it's up to 20 or 30 minutes. The government of Ontario, through the Attorney General, Ministry of the Attorney General, and the Ontario provincial courts and the Ontario Superior Court, also has a plethora of information available to the public. Everything from child to spousal support, information about divorce, information about domestic violence. Unified family courts, there's several of them in the province, have a family law information center in the courthouse that you can walk into and pick up paper brochures and speak to somebody at the counter to get assistance. There's usually duty counsel and mediators available at the courthouse if you're going to court, either remotely or on site, depending on the type of hearing that you're having. So the resources are out there. Speak to a lawyer, speak to your family doctor, speak to a friend who's been through it to make a start, do some internet research in terms of reliable information. Certainly the government of Canada, the government of Ontario, if you're residing in Ontario, Law Society of Ontario are great places to start. Ministry of the Attorney General, Ontario Superior Court website, and certainly our website and other local professionals. So the resources are plentiful, so please use them. And most of them initially are at no cost. Back to you, Steph.
Russ, I know it's 6 o'clock. Are you all okay if we have one more question that came in?
Let's do a couple questions. And and you got the teaser?
Don't forget, make sure.
Some people stay to the end, so let's not forget about that.
So one other question that came in is specifically around step parents and or grandparents having time with the children. So Joseph, I'm going to actually flip this over to you. What rights, if any, do step parents or grandparents have with respect to parenting time or contact and visitation?
Yeah, for sure. Thanks, Steph. So in Ontario, step parents and grandparents do not actually have automatic rights to visitation to children or to their grandchildren or their stepchildren. However, under certain circumstances, they may seek permission from the court to have this access or these visitation rights. Concerning step parents, so as I mentioned, step parents do not have an inherent legal right to visitation with their stepchildren. However, if the biological parent with whom the child between the two of them resides with, and they allow for this visitation, then the step parent may have access during those times. If the relationship between the child and the step parent is significant and ongoing, and it's deemed in the child's best interest, the step parent may actually apply to the court for access or visitation rights, and that's through a contact order. And with respects to grandparents, as well as step parents, grandparents do not have automatic rights to visitation or access in Ontario. And same as with step parents, they can also seek this permission from the court for parenting time if they can demonstrate that such parenting time would be in the best interests of their grandchildren. And with that, the court will consider various factors, including the nature of the relationship between the grandparent and the grandchild, the reasons for seeking such parenting time, and as always, the impact on the child's well-being. As well with that, they can apply for what's called a contact order. And if the grandparent actually wants to be able to make decisions and have decision-making responsibility, that can be done through a parenting order.
Thanks, Joseph. And then the other one that came in, we'll just touch on quickly. Can children... Okay, so this sort of touches back to what we discussed about the voice of the child, how children can express their views or their preferences. Sometimes even I've seen, separation agreements emphasize that as children grow up and get older, they might have more of a say, as they approach their teenage years, they might, want to spend more time with their friends or at, going out to camps or things like that. So, we have the Office of the Children's Lawyer, so that's a Section 112 assessment, or the private assessments that are done. All right, so I'm going to be mindful of the time. We are a little bit over, and we did promise that we would be sharing some news or some.
Let's give Shanza one more question. We can't let her off that easy. We've been giving her the hard stuff all night, parental alienation, everything else. Let's give her a zinger.
A zinger. All right. Okay. So this one, how do courts handle allegations of abuse or neglect in parenting decisions?
Yeah, violence is taken seriously by the courts, especially if there's concerns about well-being. I know I hit on alienation and all that at the beginning. Going to courts is definitely something that parents can do. And the law defines family violence, and it doesn't have to be just physical. It could be psychological, any harassment. It covers all of that. So if there are serious concerns about violence and well-being, seek urgent relief from the court. But in terms of parenting, I do want to hit on something though, which is courts do try to give as much contact as possible to both parents. So if there's no negative impact on the children, so there is a possibility that the court will provide parenting time to the parent. As long as that violence doesn't involve the kids, doesn't impact the kids, there could be safeguards in place. It could be at a neutral spot. It could be supervised. But as long as if the violence is not hurting the kids, then the courts will try to give some sort of parenting time to both parents.
Thanks, Shanza. All right.
Thank you, guys. You guys are such pros, and I want to thank our audience for joining us so late this evening. But great job as always, Steph.
Thanks, Russ. Thanks, Joe, and thanks, Shanza. Bye, everyone.
Go ahead.